You are on bond for a theft, and now you've picked up another theft and an evading arrest. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 13th, officers were dispatched to a theft call at Lowe's. The officer spoke to the complaining witness, who's the loss prevention officer. The loss prevention officer stated that the defendant entered the store and
And here we go. Notice the judge immediately points out that the defendant was already on bond when he picked up 2 more charges. In court, this is one of the fastest ways to lose your freedom. If you're out on bond, rule number 1 is do not get arrested again. The judge is basically saying, you broke the deal.
speaker into his backpack. The loss prevention officer followed the defendant around the store. The defendant walked out of the store, passing all points of sale.
Hold on.
To purchase the item.
Oh, you didn't?
Yeah.
I was going to give him a coloring book. Okay, go ahead. So he's in Lowe's?
Yes.
All right.
The complaining witness attempted to stop the defendant. The defendant did not stop. The officer was on scene when the complaining witness was attempting to stop the defendant. The officer told the defendant to stop running, and the defendant did not comply. The defendant ran approximately half a mile from the Lowe's. The officer caught up with the defendant on the 3rd floor of an apartment complex. The defendant attempted to resist detainment. The value of the item stolen was $129. And the defendant started to run from the complaining witness.
This right here is the moment everything changes for the defendant. Once the bond is revoked, you're not going home. You're going into custody immediately. The apology doesn't matter anymore. At this point, the judge is signaling accountability over sympathy. Question for the audience. Do you think bond should be revoked every time someone picks up a new charge? Or should context matter?
Mr. Castillo, I'm going to find that there's probable cause to go forward on your theft and your evading arrest. Deputy Miranda, I'm now revoking your bond on your first case. You will now go into custody. I told you not to pick up any new cases. You've picked up 2 new cases. You will now stay with me. Goes with you.
I'm sorry about that, sir.
Can you appoint him a lawyer, please? I will appoint you a lawyer now, and we'll talk, but no, you can't continue. Unacceptable. Are you Jackson Norton?
Sir.
Mr. Norton, you were charged with 2 counts of assault bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
February 15th, officers responding to 1025 West Mass Parkway, Bar Buckwild in Harris County, Texas, regarding a disturbance. The first complainant stated that he was located at the bar ordering drinks and was in a conversation with the defendant. After the complainant turned around and the defendant struck him on the right side of his face. A second complainant stated that he observed that the defendant was leaning over the first complainant, physically hitting the first complainant. In an attempt to break it up, the second complainant grabbed the defendant, and the defendant turned around and punched him on the side of the head. The second complainant stated that he believed he was unconscious for multiple seconds. When he woke up, he was laying on the ground. The defendant left the establishment where his bouncers were able to locate and detain the defendant in the parking lot. A witness, the bartender, observed he still on the second complainant. The second complainant had injuries to the left side of his face where it was pink, and there appeared to be broken blood vessels under the skin, with small laceration near the end of his eyebrow, where there was a small amount of blood. The first complainant advised he felt pain and had a small little bump on the end of his elbow next to.
Notice how the judge is not just punishing. He's trying to prevent another assault. The ankle monitor no alcohol condition curfew is designed to stop the behavior at the source. This is where the court system tries rehabilitation instead of immediate incarceration. The big question, will it work this time?
His eyebrow next to his hair.
So we have 2 assaults that were dismissed early last year. Any of the complaining witnesses the same?
No, Judge.
Same set of facts, whereas alcohol as well?
The previous assaults happened at a high school graduation party.
But there was alcohol?
Yes, Judge, it's not that there was alcohol.
Mr. Norton, I'm now going to find that there's probable cause to go forward with your case. I'm now putting an ankle monitor on you so I know that you're not consuming alcohol. If I find that you do, I will put you in jail and I'm going to make your bond high. Do you understand?
Yes, sir.
We're now working on our fourth, so I will do everything in my power to protect my public at all cost. Do not use alcohol, do not use illegal drugs, no weapons, no going to any bars, clubs, establishments where it's 50% or more alcohol, no going out in the middle of the night. You will get a curfew as well.
Judge GPS. Whisper.
Sure.
9 to 6.
Sure, yeah.
Judge, I leave earlier in the morning for work.
I'll give you a lawyer. I'll have the lawyer talk with you, work out any kind of detail, but my concern and my only concern is the protection of my city, and I'm going to do it at all costs.
Yes, sir.
Do you understand?
Yes, sir.
Nothing else matters to me in this life right now. If I find that you're a danger, I only have one place for you.
Yes, sir.
Waive all the fees, please. Mr. Norton, I'll have you fill out an application for an appointed lawyer and I'll see whether you qualify. I'll have you go to Victoria, sign a reset. Deputy Miranda's going to give you an application. I'll have you take your seat in the jury box. Do not leave until you sign all the conditions. And then I'll take a look at the application, sir.
Yes, sir.
Jackson Norton, you just gave him bond conditions, and I wanted to know if we can amend the curfew because of his work.
Okay, I knew that he had issues. What would you like?
Judge, he'd just like to remove the curfew, but keep the restriction from any bars or alcohol, or places that serve alcohol, so that he doesn't go around there. But his
So
job
what I
is-
said is he cannot go to any establishment where it's 50% or more, where there's like a true bar. If he's going to like a Longhorn Steakhouse, if he's going to, Papacitos, that's okay. But if you're going to a bar like the Marquee or you're going to, that's unacceptable. No bars, nightclubs, anything of this nature, because I don't want him to, we're working on our fourth assault now. No, and so I don't want him out in the middle of the night. I'm willing to work with you on the curfew, but
So from what he's told me, he works 8-hour shifts, but he's also he's maintenance, so he can be on call and may have to leave at 4 o'clock in the morning to get to work if there's an emergency. So he just wants to make sure that he won't be violating bond conditions if he has to go to work. My documentation that he.
right, I need proof because I'm not going to take his word for it. So bring me proof and then we can talk. But yeah, I'm not going to take his word for it that he gets up at 3 a.m. or 2 a.m. to go to this place and that place and, So, but show me something like that and then, yeah, we can work.
Okay, so we'll keep the curfew in place, and then if he needs to travel forward, we can provide proof that he's clocking in and clocking out.
No contact with any of the complaining witnesses, no weapons. And then he's got the device on his ankle, so we know he's not consuming it too.
Is that a scram? Okay. So scram and GPS is what you're doing?
No, I didn't. Well, yeah, I guess so that we know that he's not out in the middle of the night, and if after some time, if he's good, then we can amend the conditions as far as the GPS. Scram.
30 to 60 days?
Be proactive. You know what I mean? Show me, I want to know that there are not going to be any more issues, but yeah, okay. Thank you.
7 to 7?
No. I don't know. He said he had a problem with 6. I did know. What did I do? I didn't do 7 to 7.
Sorry, we're gonna do 9 to, the standard 9 to 6.
9 p.m. to 6 a.m.?
Yeah.
I think he has to be at work at 6 a.m., right?
Yesterday?
Can you
Okay,
come
so I'll
up
do 5 a.m.
5 a.m.? 9 p.m. to 5 a.m.? Okay.
So just yesterday, I worked from 6 to 11 at night.
Yeah, I'll give 5 in the morning,
Thank you.
but don't want any more issues.
Natalie Curley, can I do like midnight? Because sometimes it's 30 minutes to drive back home and I get off at 11.
Not giving you till midnight. It's not going to happen. And I want proof of anything that, as far as work is,
Requires like
I'm not going to take
a
your
tub or
word for it. So I need proof that, that they're actually working at this time and then we can work on your schedule, but I'm not letting you out in the middle of the night. It's not going to happen.
Sir.
Okay? Thanks.
Judge, 9 to 5, Judge. 9 P to 5.
9 to 5, right. Yeah.
So we're gonna amend this.
So, Mr. Ibarra, you were charged with driving while intoxicated, second offense.
Yes, sir.
You have worked out an agreement. They're offering you 30 days in jail, credit for the 2 days that you've done. You need to understand something very important, that you are making a lifetime decision today and a very serious one, because anytime you get pulled over from now on, an officer is going to look you up and they're going to see DWI, yada. What do you think they're going to do if they come up to you and they smell alcohol?
Go straight to jail. Bring me to jail again.
Right. This time, though, you're looking at 2 to 10 in the penitentiary.
Sir.
Because then a third DWI, it's a third-degree felony. You're looking at a whole boatload of time in custody, up to 10 years in prison. And all you need to do is just have the faintest smell. Do you understand?
Yes, sir.
If I were you, even if you had a sip of alcohol, I wouldn't get into a car because it's a huge risk. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty to this, it will go on your record. It'll stay there for the rest of your life.
Understood.
This is what you want to do.
Yes, sir.
How do you plead to the offense, sir?
Guilty.
I will find you guilty, sentence you to 30 days in jail. I will give you credit for the 2 days that you've done. I am going to suspend your license for 1 year. What do you do for a living, sir?
I work at a refinery.
How?
Aviation thing.
Okay. The reason I'm asking you is because there is a surcharge that you're going to be required to pay. We will give you time to pay it, but this is a second offense, so you're going to be required to pay it. It's a $6,000 surcharge that tax onto you. And if you don't pay it, every $100 you owe, you will sit 1 day in jail. Do you understand?
Yes, sir.
I'll waive the court costs.
Yes,
He's
Your
going to
Honor.
be required to pay that fee.
Yes, Your Honor. And Your Honor, I did have one request that I wanted to put forth before the court. Due to his job, he is a foreman at his job. I wanted to see if possible if the court would consider allowing him to do his jail time on weekends.
No, like
He
you said,
said he can literally do every weekend until it's satisfied.
we're not allowed to do that.
I explained to him the court's general rule.
All right. You're going to have to do it flat. It'll be easier now. If you want to go in later today, by 6 p.m., we can do that. If you want to go in now, you can go do that now, but it's got to be a continuous
Yes, sir.
stretch. What do you want to do? You want to go in now or do you want to go in later
Bring it
today?
down.
Right now?
6
Yes, sir.
p.m.
Okay. All right. So Deputy Miranda, do you mind remanding him into custody so he can serve his time?
Be back 10 minutes. All right. Thank you, Your Honor. Not be excused. Have a good weekend. I told him the court's policy, Your Honor, but he
Yeah.
still wanted me to ask.
Problem is that it costs way too much in man time.
Yes,
We don't
sir.
even do sweep anymore, which is like a work release program. They don't do any of that anymore. Since COVID, it's
Okay.
all,
All right. Thank you, Your Honor. Have a great weekend.
let me see. Okay, guys. Yeah, take care. Yeah, come on up. Hi, James. Come on up.
Sorry about that. I was in court 7 all
Don't worry
morning.
about it. I'm happy to have you,
Mr. Vera has been in bond forfeiture for a long time, or? Let me see, Judge.
So you're still on it.
Yes, Judge.
I'd like you, please, because
Sure.
what I'm gonna do now is, I'm putting an ankle monitor on him.
Okay.
Come up. Come up.
You mean a GPS monitor or a SCRAM device?
Oh,
Oh, okay. One for each ankle. Okay.
get a curfew of 7 to 7. And then is discovery complete? Please tell me it is.
Yes, it's complete, Your Honor.
You have 2 weeks to figure out what you want to do on this case. You must be back here in 2 weeks and I will either set your case for trial or you will accept a plea bargain agreement. But you have multiple bond forfeitures. You have had bond violation after bond violation after bond violation. Today, you get 2 monitors. One is a scram, so I know that you're not consuming alcohol. The other one is GPS monitor, so I can keep tabs on you. And let me express in the event that you ever take off on me, I will do la cucaracha on your bond. Do you understand? Do you have an offer on this case, please?
Yes, we have both a 30-day and an 18-month probation.
You're not to consume alcohol, illegal drugs. You'll be randomly tested. Does he have a Texas driver license, please?
Does he have one? I'm gonna run it right now to see if it's eligible.
There is already from 2023 an order for you not to drive. You are not to drive. I don't care what's going on in your life. If I find that you're driving a car, I will have a contempt hearing. You understand?
His license is suspended.
Okay. You don't have a Texas driver license. You are not allowed to drive. One ankle, you understand you'll get a scram monitor, your other ankle a GPS monitor, and I'm giving you a curfew of 7 to 7. Back here in 2 weeks, you must accept the plea bargain agreement. It is your responsibility to get with Mr. Sims. If you do not get with him, then if you have immigration issues, it's your responsibility between now and then to also see an immigration lawyer as well. Do you understand?
Yes, sir.
Okay?
Thank you,
All right,
Judge.
I'll see you in 2 weeks. You will get with Felicia for your bond conditions.
Just, do you want to have a seat in the jury
I can
box?
see him
Judge?
right now.
Oh, okay.
Mr. Carollos,
Yes, Your Honor.
sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay,
Just
please.
remind me of the last name, please. Sir.
Carollos with a K.
K-I-O. Thank you. On or about February 15th, officers paced a vehicle going 80 miles per hour in a 65 mile per hour zone. A traffic stop was initiated. The defendant was the driver of the vehicle. The officers observed slurred speech, an odor of an alcoholic beverage, and the defendant appeared disoriented. The defendant stated that he had drank an IPA juice a few hours before at a friend's house. The standard field sobriety tests were conducted. 6 out of 6 HGN, 2 out of 8 walk and turn, and 0 out of 4 on the one leg stand. The DIC was read and consented to. The defendant blew a .139 and a .131.
Okay, any prior DWIs?
No, Judge.
Okay. Mr. Carollos, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you test positive for drugs or alcohol, if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
You have a lawyer because you have one. I will waive your appearance. So you don't have to waste your time coming to court, but stay in touch with him and he'll tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, likewise, I'll issue a warrant for your arrest. Do you understand?
Yes, Your Honor.
I'll have you sign a receipt with Victoria. We'll have you get with Felicia for bond conditions, and then you guys are free to go.
Judge, one thing I wanted to address, I've already spoken with pretrial services. My client has a work trip scheduled for this Sunday through this Thursday
Okay.
out of state. I would ask, apparently it's not going to be a frequent thing that he's traveling out of state. Would you
Okay.
consider waiving the drug testing until Friday of next week when he
Well,
goes?
I mean, from the time of the trip to then, okay, but you're not allowed to use. I'm going to test you as soon as you get back. If you test positive, it's really not going to go well for you.
Yes, Your Honor.
Okay? Okay,
Thank you.
absolutely. Happy Friday.
Happy Friday. Buenos días, señor.
Buenos días.
Parece aquí, por favor, conteste a voz alta.
Okay.
You are Mr. Pavez Vargas.
Vargas.
Sí.
Yes.
Sir, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine.
De $2,000.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 15th,
El 15 de febrero.
officers
Los
observed
oficiales observaron
Nissan SUV failed to maintain a
que no
single lane
mantenía una vía
5 times
5 veces
and observed it
y
to slow down
observaron que
and
fue a la
rapidly
velocidad
accelerate
y rápidamente aceleraba
several times
varias veces
before initiating a
antes de
traffic stop.
iniciar el alto.
The officer observed the
El
defendant to be
oficial
confused
observaron que
and
el
delayed in
acusado
responding
se
to
tardaba
his
en
questions
responder a las preguntas
and struggled to locate his
y
driver's
luchaba
license.
para localizar su licencia de manejar.
The defendant
El
advised he was coming from a wedding
dijo que venía de una boda
and he had one
y que
beer.
había tomado una cerveza.
Standard field
Le
sobriety
hicieron
tests
las
were performed,
pruebas de campo,
4 out of 6,
4 de un 6,
HDN,
HDN,
4 out of 8,
4 de
walk
un
and
8,
turn,
caminar en voltear,
3 out of
y
4,
3
one
en
leg stand.
4 para una pierna.
The defendant consented to breath
El acusado dio permiso para dar su aliento
and he blew a
y sopló
.08.
.08.
You said that he
Sí.
5 times
5 veces
failed to maintain a single lane of traffic.
una vía de carril.
And you said that he slowed down
Su
and
velocidad
then he sped up.
Yes, Judge.
What else?
¿Qué más?
Because as far as the 5, that's just completely conclusory. So I take nothing with it, right? I mean, everybody slows down, goes back fast. So
Bajan su velocidad.
what else do you have as far as any kind of traffic infraction
Nosotros,
other than that?
pico,
That's what
aparte
I'm
de eso,
reading in
eso es lo que leo.
this judge. Let me see if there's
En
any
esto,
more
señor.
information in the office.
Su señoría, deje ver si hay que no vamos en la defensa. Me reporte.
It does say that
Dice
after the
que
emergency equipment was turned on,
se
the
prendió
suspect failed
el
to
equipo
pull
de
over for
emergencia.
approximately 2 minutes.
Que él no se paró por aproximadamente 2 minutos.
I don't know if he articulated more maybe in an OR, but there's just not much there. I mean, Blaze, I can give you a little bit of time if you want to try to pull the OR, maybe like 10, 15 minutes.
Poquito más para que miren a ver lo que hay. Otros 10 o 15 minutos. Y que no se mantuvo en una vía, en un carril.
Okay. All right, Mr. Pavez Vargas, I'm going to find that there's no probable cause to go forward in your case. Sir, we have enough death and destruction on our streets as it is. Be mindful of this. If you want to have 15 beers, 32 shots of tequila, take an Uber. Save yourself the trouble.
Tal vez
Do you understand?
entiende.
Yes, sí.
Okay. All right. Thank you. Please.
Next is page 13, Rodriguez, come on up.
With either of the complaining witnesses, right? No going to like bars, clubs. Are you Luis Gilberto Rodriguez?
Sir.
Mr. Rodriguez, you were charged with reckless driving. You were facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
14 officers were assigned to after crimes unit in Harris County, Texas on an operation targeting illegal street racing and parking lot takeovers in an undercover capacity. An officer at 11737 East Tex Freeway in Harris County, Texas, observed the driver of a 2007 flatbed Ram perform multiple donuts in the parking lot. The vehicle was maneuvered in tight circular motions, causing the rear tires to lose traction and produce visible smoke at all stations. That Ram headed towards the exit of the parking lot when the vehicle executed a burnout, causing its tires to emit smoke and a loud screeching noise. As the driver of the Dodge Ram initiated a turn to proceed east on East Mount Houston Road, while the vehicle fishtailed. During the maneuver, the Dodge Ram flew closely, striking several vehicles and almost avoided multiple accidents. The officers conducted a traffic stop on the vehicle.
Got it. Can you look to see any priors of this same or similar nature? Please.
Yes, Judge, I'm not showing any criminal history.
No? Okay. Mr. Rodriguez, or one more thing, if you can look for a license, please,
Yes.
valid license. Mr. Rodriguez, I'm going to find that there's probable cause to go forward with the case. Let me just give you a little warning that the Texas legislature has made it very easy for DAs across the state of Texas to seize and take cars for people who participate in this type of activity. In fact, I think that there was a news conference maybe 2 days ago where they're cracking down on this type of behavior. And I've seen it where here we have people who've had their cars seized and taken when they're multiple times in this. Do you understand?
Valid driver's license.
I'm ordering you as a condition of your bond not to participate in any street takeovers, donuts, reckless driving, anything of this nature. If I find that you do, I will revoke your bond and put you in jail.
Yes, sir.
And then I will take your driving privileges away.
Sir.
Do you understand?
Sir.
So do you mind filing that no reckless driving, donuts, et cetera. All right, Mr. Rodriguez, how old are you, sir?
18, sir.
Do you have the ability to hire a lawyer? Would you like to apply for a court-appointed lawyer? Okay. Deputy Miranda, Deputy Miranda's going to give you an application. I'll have you sign a wreath of Victoria while you take a seat in the jury box. Do not leave until you sign our bond conditions. You
Yes, sir.
understand? Okay. This is the one where you remember? It was like maybe 2 days ago, the two Bs?
Yes. Yeah, yes, sir. I do.
Good morning, Ms. Harrison.
Hey, good morning.
Ma'am, you're charged with tampering with the government record. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On February 15th, officers observed a vehicle temporarily tagged. The officers ran a temporary tag and returned to court. Defendant Martin was the driver and defendant Harrison was the passenger. Defendant Harrison stated that she was the owner of the vehicle and that she had purchased the tag from an unknown individual off Facebook.
Okay. Ms. Harrison, I'm going to find that there's probable cause to go forward with your case. Can you run her license, see if she has a valid Texas driver license, please?
Yes, it's not found.
Okay. Ms. Harrison, did you want to apply for an appointed lawyer? Do you have the ability to hire a lawyer?
Apply for one.
Okay. So Deputy Miranda's going to give you an application. Do not drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? These are your bond conditions. If I find that you're driving without either, I will revoke your bond, put you in jail. Understand, ma'am?
Yes, sir.
Okay, please.